Good morning, Mr. Boglowski. Now, we're hearing both of these cases, and I appreciate the efforts of counsel to work out so that we can have the benefit of you in a reasonably coherent way. So, as I understand it, you have 15 minutes.
Good morning, Your Honors. Thank you. May it please the Court, I'm Mark Bobrowski, and I represent the Board of Appeals of the Town of Canton. The Canton case focuses on a key provision of Chapter 48, Section 20. The statute provides that where the municipality has not attained its 10% goal, the Housing Appeals Committee has jurisdiction to review an appeal by a developer. At the Housing Appeals Committee, the agency determines if the local decision, the Board of Appeals decision, was reasonable and consistent with local needs. The definition, Chapter 48, Section 20, of consistent with local needs contains the provision that we're here to interpret this morning. In the special case where a municipality has achieved its 10% goal, requirements or regulations shall be consistent with local needs when imposed by a Board of Appeals after comprehensive hearing where low or moderate income exists, which is in excess of 10%.
Mr. Bobrowski, this 10% is really a creature of the housing of the DHCD's regulations, is it not? In other words, it comes about in your case and in most cases, I would assume, because the agency has given you the right to treat 100% of rental units as low and moderate income housing when only 25% are.
Yes, Your Honor.
So I guess the problem I have with this argument is if you get to the 10% by the grace of the regulation, why aren't you bound by the regulation that says, you know, we're going to be able to decide whether you have reached your 10% or you haven't?
I think that'll be a substantial disincentive for the construction of rental housing for 15 years.
But what if the agency simply said, okay, let's play it the way the statute has it written. 10% means 10%, not 25% of 100%.
The agency has the authority to do that. But DHCD has, first by policy, now by its counting regulations in the subsidized housing inventory, counted rental projects where 25% are affordable or 20% at low income in their entirety.
You suggest that's a jurisdictional issue, and I guess I have, well, if it exists only by virtue of regulation, how could it be a jurisdictional issue?
I think the DHCD is operating on the count in its subsidized housing inventory. It has chosen to honor rental units where all of them count. That's a policy decision that they chose to make. But I don't think that should factor into Canton's accomplishment or any other town's accomplishment. They know, as their long-term planning objective, that a rental project will count. They've been sold that bill of goods by the DHCD SHI, the Subsidized Housing Inventory, and they're entitled to make careful, long-range planning decisions on that basis, not just a world in which only the affordable units count.
Could we say that, could we go back to what I think Hack used to say, that it was at the time of filing of the, at the time of the application?
That was a decision, the Greenfield decision discussed that as a premise, and the Housing Appeals Committee in its Casaletto decision chose the time of the filing of the decision of the board with the town clerk.
But that's a time that can be monkeyed around with too. So if you took the filing of the application, why wouldn't that be the fairest date? And then it wouldn't change. Then it would be that way forever.
Well, I think that the time of the filing of the application would lead to a world much like we have now. Canton, as a result of the Housing Appeals Committee decision, has 2.695% additional housing over and above its 10% goal. 227 units were approved by the Housing Appeals Committee in the CPH decision. And
I think that's terrific.
I agree with you. Amherst would agree with you in the Boothroyd case. And Canton might agree with you for the right project. But the CPH project was not the right project for the town of Canton. As a result of the HAC decision, they have 227 units, they think, in the wrong place, all of which are over the 10% count. And that is an unreasonable result based on the holding, we think, in the Greenfield case. That wasn't any of the rationale that Judge Grabeau provided in ruling for the town. We did brief that and we did argue it, and we do have...
But under Greenfield, you would have lost, because it would have been measured as of the date of the application.
I understand that in the Greenfield scenario, even if you measured it as of the date of the application, they were at 9.33% in Greenfield at that time. I think they needed 49 units to go over. They had a 60-unit proposal. And the court ruled that 11 units was a reasonable result. But I got the briefs from the Greenfield case, and I note that the lawyer for the town argued, What if the application was not for 60 units, but for hundreds of units? And the court said, well, we'll reserve that for another day because that's not the case here. We're here today. Today is the day. The town of Canton was ordered by the Housing Appeals Committee to go 227 units over the 10% count. And Housing Appeals Committee knew at the time that they ordered the CPH permit that Canton was over 10%. They were at 10.2%.
But don't we need to, I mean, we run on deadlines, 30 days after the judgment, you got to appeal, all this kind of thing. Don't we need a fixed time, whether it's time of filing of the application or time of the issuance of the permit, to say, that's when this number will be fixed? And
Well,
anything pending up until that time is in.
I think we need a fixed time, but I think that the statute, without ambiguity, provides that fixed time. When the housing exists, I feel like former President Clinton a bit, exists is exists. When the housing exists, then we have the 10% goal achieved.
But isn't it true that the housing didn't exist?
It certainly existed at the time the Housing Appeals Committee made its decision.
It existed? It was not in the ground.
It existed for purposes of the standard practice of counting the units of the
Existence
agency
doesn't mean-
itself.
And that's a regulation, the same regulation that deals with when the units will be counted.
But I might add, Justice Cordy, that the housing in Canton that was the result of the Pequot settlements does have a building permit today and is proceeding.
It doesn't
apace.
exist, does it?
It's moving forward. They have
doesn't
their building
exist.
permits. It hasn't ever dropped off the rolls in terms of not getting a building permit within a year.
In it, correct?
I'm not familiar with the state of construction out there, but they did obtain a building permit. They did not come off the rolls for failure to obtain a building permit in that year. They are moving forward apace and have been every day since they achieved that goal in August of 2004.
I think the import of the questions, though, what does exist mean for purposes of the statute?
Well, I think you have to fall back on the agency's own counting methodology. The agency has decided that exists includes rental units, which are market rate. It includes units which are subject to a comprehensive permit, but which have not yet been constructed. That's the way the rules have been outlined by DHCD.
Because of the way this case happened, you would have your right to argue that 227 units was inconsistent. I mean, you could argue that on the merits, quite apart from this timing. I mean, you didn't do it because of Judge Gerbeau's decision, but that was available to you, right?
Well,
I mean, the fact that the Housing Appeals Committee decided it doesn't mean that that issue isn't appealable, even if you adopt the Housing Appeals Committee view of when you measure the 10%.
Well, we asked Judge Gerbeau to rule on the unreasonableness of the overage, for lack of a better word, and he did not reach that question because he decided on the basis of the second statutory purpose, which I identified. And I think that's the lost issue in all of this. Clearly, Chapter 40B is to promote the development of affordable housing. We concede that. But just as clearly, this Court has ruled on at least 2 occasions in both the Hanover and the Wellesley case that a secondary objective here is to promote sound and rational long-range municipal planning. Municipalities need to be able to figure out how to get to the goal, and they need to be able to pick and choose between projects in order to do that. And I think that the Court has also indicated in a couple, maybe the same case, the Hanover case, that is a precise endeavor and that there's a careful balance that is to be had. The consequences of reversing Judge Gerbeau do not create certainty for municipalities, and frankly, in my opinion, they don't create certainty for developers either. The current Casaletto decision has within it a series of contradictions that plague 40B practice right now. Consider Casaletto. At the time of the application, at the time of the decision with the town clerk, that's the number that we fix in place. Consider the scenario in Canton. There were 2 applicants competing for the last spots under 10%. There were actually 3, but 2 of the applications were by the same entity or an entity controlling the
But
project.
you're not required to stop at 10%.
Again, you're assuming that the municipality favors the project. In that case, I would very much agree with you. But there are projects out there which municipalities don't favor, and they do want to exercise their 10% right. So in the Canton case, we have a perfect example of what Casaletto inspires in practice. The Board of Appeals must choose one, and it will take them over 10%. It need not choose an order. There's no rule that says the applications have to be decided in the order that they are submitted. So if an application comes in from late blooming number 2, and the board favors that application, it can drag number 1 out, move number 2 forward quickly, approve the project, await the expiration of the appeal period, and turn around the denial and deny developer number 1, who may have spent a considerable amount of money to come close to but not over the finish line.
Well, one of them is going to be denied anyway.
One of them may be, certainly one of them may be denied, or both may be approved in a perfect world where both projects are good. But the developer has no certainty that he will be the person denied, where the other one races to the finish line first. And what would you do if you were the developer is often the question that I face. The developer typically will consider at least filing suit to block the counting of the one that the board has chosen to approve. In fact, that is exactly what happened in this case. CPH appealed the approval of the Pequot settlement at Housing Appeals Committee in March of 2004. It was dismissed in August of 2004, and we appreciated that, but they still appealed it in order to hold up the count.
No matter how you look at it, it's messy. I mean, here, you know, they approved this. It was on appeal to HAC, and as I understand it, you reached your 10%, right?
The town approved the settlement with Pequot while it also was pending at HAC.
Yeah.
It was appealed by CPH.
So you said to this one, you're out, because we've reached our 10%.
Once the appeal was dropped,
So that developer spent an awful lot of money, too.
we agree. And we're sympathetic with the fact that the CPH appeal was dropped and the municipality achieved its 10% goal, and at that point in time, CPH had spent a lot of money because town went over 10%. But that's the risks of doing business here.
Well, that's why I said,
To rule otherwise
under your first hypothesis, before we got to this one, that's the risk of doing business.
And to rule otherwise would dishonor the objective in the statute that would allow the municipality to promote sound and rational long-term planning. The municipality made a very careful choice here to choose the Pequot proposal, and they did not like and continue not to like the CPH proposal. Otherwise, there would have been settlement. If Judge Grabeau is wrong, then there's equal uncertainty. That's my point. The Housing Appeals Committee case, the town goes over 10% while someone is pending at the Housing Appeals Committee that has been denied. I see no possible incentive for the town, having denied it once, to now do anything but litigate it to the bitter end. So there's, I suppose, a certainty in that, but it's a long ways out, 3, 4, 5 years in some cases, including this one. And there's no incentive for the town, meanwhile, if they're prevented from going over 10% by a developer suit, from approving anyone else.
Well, how does Boothroyd affect all this?
I think Boothroyd is a very positive case, and I appreciate that municipalities like Amherst and Cambridge want to do the right thing, stay over 10%, provide affordable housing in the right place for the right project. That's what Boothroyd's about. This is about a project which is going to cause traffic snarls on Route 138 at Randolph Street beyond what exists today, that the municipality simply did not choose to live with.
There's probably an answer to this, so just provide it to me. If I accept your logic that if the town reaches 10% while something's pending before the Housing Appeals Committee, does that also apply if on appeal to the Superior Court or on appellate review, if you reach your 10% somewhere along there? I mean, where does this end?
Well, I'll leave that for the court to decide. I knew that that was a likely question to come my way because it was raised in Judge Kottmeyer's decision in the Taylor case. What we have here is a clear procedural trail that on 2 occasions, while the HAC, a year before the HAC had decided the case, it was asked to dismiss, first in March of 2004, and again when the appeal was dropped in the Pequot settlement in August of 2004. We moved to reopen the hearing to introduce that evidence. This case was not decided by the Housing Appeals Committee until September 20th, 2005. So more than a year went by with the Housing Appeals Committee fully aware that the town of Canton was at 10.2% as certified by the DHCD subsidized housing inventory. This is a case of absolute notice to the Housing Appeals Committee on point.
But
I think I would respectfully suggest that this court does decision-making like this all the time. I teach my students at New England the Albrecht case, in which you ruled just 4 or 5 years ago that there's a builder warranty of fitness for the first purchaser. What about the second purchaser? You didn't decide that case. It wasn't in front of you. I'm sure it will be coming shortly. But I'll leave that to
Perhaps you'll bring your
We got enough
students to,
trouble for today.
I'll leave that to the next person.
Yeah.
and
we
you'll
got
bring your
enough-
students to hear the argument.
Yeah, well, they'll have graduated by then.
But he's going to teach the same course over and over again.
That's my fate.
Thank you.
Thank you, Mr.
Thank you very much.
Bobrowski. Mr. Whitten?
Thank you, Your Honors. Good morning. May it please the Court, Jonathan Whitten for the plaintiffs' appellants and Barbara Huggins with me. Your Honors, in this case, the trial court ruled in a different manner.
This is
than-
Judge Kottmeyer's decision?
Judge Kottmeyer, Your Honor, that's correct. Judge Kottmeyer ruled that the date of determining when a city or town is consistent with local needs is the date of the Board of Appeals decision when it's filed with the municipal clerk's office. That is very different than Judge Grabeau's decision. And we're here on appeal, Your Honor, suggesting that Justice Kottmeyer is incorrect, Justice Grabeau was correct, because Justice Kottmeyer's decision is inconsistent with Hanover. It's inconsistent with Wellesley. It's inconsistent with even Boothroyd. This Court has made clear that the Housing Appeals Committee's power to override a Board of Appeals decision is extinguished when a city or town meets one of the statutory criteria.
it's not a statutory, it's a regulatory grace.
Your Honor, the 10%, there are 3 statutory criteria. The 10% is 40B Section 20. The HAC, or the Department of Housing and Community Development, has added additional criteria for consistency with local needs. But the one at issue here is a statutory criteria. 10% of the housing stock is subsidized.
So you would have no trouble if the HAC just changed its regulations and required actually 10%? Well, you wouldn't.
Your Honor, are you referring back to the colloquy with my brother regarding how to count the 10%? Well, the DHCD is free to choose, based on its discretion, how one defines the phrase subsidy. That was in part the Middleborough case, which was from last year. The way it stands now, though, is that the town gets to count on the subsidized housing inventory according to DHCD guidelines.
I guess I'm just troubled by how that becomes a jurisdictional issue.
It's jurisdictional, Your Honor, based on Wellesley and Greenfield and Hanover, because the Housing Appeals Committee's jurisdiction, in this Court's own words, is extinguished once the town has fulfilled its...
Begs the question as to when you're measuring, doesn't it?
It does, Your Honor, absolutely, and I understand that that's the crux of this argument. Ironically, for Justice Kottmeyer's decision compared to Justice Grabeau's decision, Justice Grabeau, in footnote 6 in his decision, refers to the fact that there is even a different standard when there's a denial from when there's an approval with conditions. And the facts of this case is this was an approval with conditions, not a denial. An approval with conditions uses the phrases in the present tense. In approval, the phrase under Section 23, where the decision makes or are, these are present tense. In a denial, they're past tense. One could argue, I agree with my brother Bobrowski, that clearly Justice Grabeau read the phrase exists in the proper meaning. But he goes even further. In an approval with conditions, clearly in Section 23, it's what exists when the Housing Appeals Committee's decision is being rendered. In this case, on April 12, 2005, before the HAC's decision was rendered, Lexington was over 10%. It's in the record. Now, my brother suggests that it's not in the record, and I would beg to differ, and I'm happy to point the Court where it is in the record. Clearly,
But why can't the agency promulgate a rational regulation interpreting the statute? Here's how we're going to count, and here's when we're going to count. Why isn't that a rational action on behalf of an administrative agency charged with administering this statute?
it could be, Your Honor, and you would have to give it deference, but in this case, it's incorrect. In this case, their interpretation of the statute is wrong, and it's wrong because of the express words of Section 23.
But what do you do with the Greenfield decision then?
Well, the Greenfield decision, Your Honor, is not inconsistent with what Justice Grabeau said, especially when we read Wellesley, where it talks about the Housing Appeals Committee's powers being extinguished
But Greenfield adopts the view that when you measure is as of the date of the application, which was the agency's regulation at that time.
But that is then changed by the Housing Appeals Committee in Casaletto, and Casaletto is a denial.
And then it's adopted in a regulation after that.
That's correct, Your Honor. That's correct. But
But Justice Bartlett's question is correct. If it was correct in Greenfield, although I Justice Glaney noted in that case that nobody was attacking the validity of the regulation. So, the regulation said as of the date.
Well, we think, Your Honors, that the court clarified the measurement and the jurisdiction of the Housing Appeals Committee in Wellesley.
Yeah,
And Wellesley would be controlling in terms of the...
Dealing with a very different issue. I mean, aren't you sort of plugging language in? I mean, it wasn't considering this particular problem about when you measure, correct?
Well, I believe it was, Your Honor, in terms of what the powers of the Housing Appeals Committee would be once a town reaches the consistency with local needs status.
Yes, but it doesn't say when.
Not when.
That is correct, Your Honor. That is correct.
That's all I'm
But what I'm suggesting is that on April 12th, 2005, as the facts make clear, Lexington was consistent with local needs. And when it became consistent with local needs, the Housing Appeals Committee's powers were extinguished. And that is very clearly in the record. And in addition, when the Housing Appeals Committee issued a proposed decision, it then received from the Department of Housing and Community Development, the very same agency within where the Housing Appeals Committee sits, informing the Housing Appeals Committee that the town was over 10%. That was binding, or should have been binding, on the Housing Appeals Committee. The Housing Appeals Committee then thereafter issues its decision. So prior to the issuance of the decision, the HAC was notified that the town was over 10%, and the HAC, according to Wellesley and Hanover, loses jurisdiction.
Well, if that's true, why did the town stipulate that it had not met the 10% statutory minimum before the Housing Appeals Committee?
Thank you, Your Honor. What happened was clearly one of time. At the time of the Housing Appeals Committee hearing, which was over a year earlier, the town was not at 10%. That was a correct statement of stipulation. That the time of the pre-hearing order, the town was not at 10%.
Why isn't the law the case?
Because, Your Honor, it's a moving target. That moment in time doesn't freeze when the town will move forward with additional affordable housing that counts towards the SHI. The pre-hearing order is not a moment in time within which you're frozen. It was a factually correct statement that the town made at the time of the pre-hearing order. Right now, as we sign this, we are not consistent with local needs relative to the statutory criteria, not consistent.
So a town can head off a project that's about to be approved by the HAC by quickly approving another one that will get it to one unit over.
That's correct, Your Honor. That's the race that the colloquy with the court with Attorney Bobrowski. That's the way the statute's set up. And Justice Botsford was asking whether or not the town could approve more units, and of course they can. And that was clear in Hanover, and you reaffirmed that in Boothroyd. But the fact is
there's a real difference. I mean, everybody recognizes the difference. The town can do it, but they, as Mr. Bobrowski said, they are projects that the town wants to have.
Exactly.
If you're under the 10%, the town may be required to have projects that, in the town's best judgment, not because it's against affordable housing, but may have to accept because that's the project that came along.
And that's what this town did. Lexington chose the Avalon project at the Lexington State Hospital. It approved that. It put the town over the top. And that should, therefore, extinguish the HAC's review of this matter. And I should add, Your Honors, based on the earlier case.
But didn't the HAC, when the stipulation of 10% was filed, or actually, if the town did not have the 10% at the time that the ZBA made its decision, the Housing Appeals Committee gets jurisdiction. Once it gets jurisdiction, it stays, doesn't it? It can't be stripped from it.
I would respectfully disagree, Your Honor. And
Do you
that's
have case law that supports that?
Wellesley, Your Honor, in terms of extinguishing the
No,
jurisdiction.
where
Once
the
it
act-
attaches,
Filed.
once it attaches, it cannot be ousted.
Well, we don't have case law on that, Your Honor.
Well,
We do. We have an appeals court case, and it's not in the 40A, in the 40B field, but O'Day versus American Policyholders. And the federal courts do the same thing. If you have your $10,000 jurisdictional limit, once diversity attaches, it doesn't go away later because somebody moves out of the state.
But in this case, Your Honor, the legislature provided the bar, and once the town achieves the bar, then that jurisdiction to approve another project, to keep putting the town
But that doesn't make sense. I mean, why would the legislature screw up the way we do our business?
But, Your Honor, it's no different than if the line were at the Board of Appeals level. If the line were at the Board of Appeals level, then the town could stack 3 or 4 40B
That's not the
projects.
issue. The question is, does HAC, and that's what it goes back to it's another way of asking Justice Botsford's question is, why is it jurisdictional? Because I think somebody, both of you said, it is a race to the, for certain purposes, it's a race to see whether or not you can get projects built. There are many, many towns that don't have 10% yet, so there are lots of places to build. You can set it just about anywhere, and you're going to have a race to that point, correct?
Yes.
So that doesn't advance it. The question is, if you set it at point A,
The reason, Your Honors, I would suggest it's jurisdictional is because the Housing Appeals Committee has no jurisdiction if a town meets one of the statutory criteria. There is no appeal, for example, in Boothroyd, Amherst, Framingham, many other communities. If the town is meeting one of the statutory criteria, there can be no appeal to the Housing Appeals Committee. It's jurisdictional. So I would respectfully suggest it's jurisdictional once the town achieves the statutory criteria. It's the same logic. The legislature created the system of jurisdiction. You either get to go to the HAC or you don't.
but you don't, but the legislature
to the
didn't get, they
HAC.
got to the HAC.
They got to the HAC, and in the process of the proceedings, the HAC lost jurisdiction is the argument from Justice Grabeau because the town achieved the 10% milestone. And that's not illogical, Your Honor, regarding the policy of the statute,
Of course it's illogical, because by the time you get to the HAC, at very minimum, you've got developers who've gone through a long process, right? As opposed to somebody deciding to go into the process could wait until the board acted, for example. I mean, somebody who thinks that they're going to rely on the 10% can look to see, has the board acted, has the 10% been reached, what kind of projects are under consideration. These are all public documents, and you might decide to, to wait, delay, or to go. But once the board has acted and there's still an opportunity, why would you not proceed then?
Your Honor, I would only repeat that it's the same problem a developer has at the Board of Appeals level. A lot of money's been spent, a lot of time's been put into this. You're queuing up behind others. You may be shut out because the town chooses one project over another. That's no different than at the HAC.
Do you see any difference between, would you apply your argument to the Superior Court?
No, Your Honor. I would leave it at the HAC, at the Housing Appeals Committee, pursuant to Section 23. And in your question earlier to Attorney Bobrowski, that's where I would leave it, because I think Section 23 intended that it was left at the HAC. And if I could just say, Your Honors, on the facts of this case, the developer made a choice to appeal to the Housing Appeals Committee. There was a risk that the developer took. They already had a permit for 28 units, or an approval
Well,
for
certainly
28.
this developer didn't know he had that risk, because this developer could look at Greenfield and, and at the regulation.
Well, this developer knew, Your Honors, that the town was about to achieve the 10% milestone. So this developer couldn't say that there wasn't some exposure here, that if, in fact, Justice Grabeau is correct, that the town would achieve a 10% milestone and pick and choose, the HAC would lose jurisdiction, is the argument. So the developer had a permit for 28 units. The developer chose to appeal to the Housing Appeals Committee. That was the developer's choice, developer's forum. They had approval for 28 units.
Thank you, Mr. Whitman.
Thank you, Your Honors.
Good morning, Mr. Guberman.
Good morning, Your Honor, and may it please the Court. Assistant Attorney General David A. Guberman for the Housing Appeals Committee. With me are David Weiss and Brian Hurley, who will argue for the developers in Taylor and Canton, respectively. I'd like to turn immediately to some of the issues that arose during my brother's arguments. I noticed an inconsistency between the Canton argument that says that the statute fixes in time when the 10% goal is to be measured, goal being my brother's language. We say it's a threshold or a minimum, whereas Taylor says it's a moving target. And indeed, under their view of the case, it is a moving target, at least up until the point, if Mr. Whitten's view were followed, the HAC has finally concluded its proceedings, because at any time that the 10% threshold is crossed, in their view, at that moment, jurisdiction magically vanishes. We would say that the statute does fix at least an outer time limit. There is, as Hanover was the first case to recognize, a fair degree of ambiguity in the statute in a number of respects. And this court said just last term in Middleborough that where the statute is ambiguous, the deference to the agency involved is at its highest. But there is a line that the statute draws, and the statute draws a line at the time the board renders its decision.
Well, at least that's what the department has said.
That is what the department has said, and that is what the appeals court agreed with that in Greenfield.
Although in Greenfield, as you know, nobody challenged the validity of 31.041A, which is the relevant regulation, correct?
That's true, but I would suggest, I'm sure that Justice Graney's memory and knowledge of the case will govern over mine, that it was well-considered dictum on the part of the appeals court panel. Indeed, all of Greenfield was well-considered dictum because, of course, Greenfield begins by noting that there wasn't a separate final judgment entered, and therefore the appeal had to be dismissed. And then it went on to discuss all of the issues that it did.
That's a slightly different, and I don't want to mix things, but you can have you can have dicta where the issue has been challenged. Here, it wasn't challenged. I mean, nobody was, challenging.
Well, that's a fair point, and let's discuss then why it makes sense to say that the achievement of or crossing of the 10% threshold has to be measured on or before the time that the board makes its decision.
Why is the time of the count, why is it not a question of law for a court to decide as opposed to something that's committed to agency discretion?
Well, Your Honor, it is, of course, a question of law because we're interpreting the statute.
But your interpretation then is not entitled to deference.
It is entitled to deference, Your Honor, if the statute is ambiguous.
But what kind of experience in the housing development field is needed to answer the question? Why isn't it just
I would
purely a
suggest,
question
Your
of
Honor,
law?
that the purpose of the statute, the paramount purpose of Chapter 40B that this Court has identified, namely the expedited construction of needed affordable housing, raises a question committed to the expertise of the committee, or if there's a regulation, as there is in the Taylor case, to the department, a question of expertise concerning, given the statutory language, what date makes the most sense for counting.
It's more than just this issue that requires expertise to be fleshed out by the department. There's all kinds of issues, like do you count mental retardation units? Do you, count this or that? There's all kinds of issues, and I think the legislature says, well, let the department, they've got the most expertise in this, flesh out these contours.
Absolutely,
This
and
is just one.
That's what this Court said in Hanover, but I'm focusing on a specific reason why this particular issue, in answer to Justice Spina's question, is something that does engage the expertise of the agency responsible for enforcing and administering the statute.
Mr. Guberman, am I correct when I look at the regulation, which talks about occupied or available for occupancy or under permit, that under permit is the most generous in all circumstances? In other words, you couldn't be occupied or available for occupancy unless you had been under permit. Am I correct?
I believe that's at least not lawfully, Your Honor.
Well, under permit is the latest cutoff point.
No, it's the earliest.
It's the earliest.
Earliest? Okay.
It's the earliest cutoff point. To get to Justice
Yes,
Spina's
earliest.
question, what if we were to read the statute to say, first of all, we don't defer to you, and we say when they are available for occupancy, because occupancy may depend on, you can't have it going up and down. That would mean that there would be an awful lot more, there would be many, many more opportunities for building, because towns hadn't met their 10%, correct?
Yes, Your Honor.
Is there anything in the record that tells us that under permit, although a permit is issued, in fact, housing doesn't get built?
Frankly, Your Honor, with respect to the records of the individual cases, I have to defer to my brothers. I'm focusing on
But
the...
isn't there a rule, if the housing hasn't started within a certain period of time, it's taken off the SHI?
That's another.
That's a different issue, I think, Your Honor.
Yeah, available for occupancy would be a disaster for these folks, because occupancy can be held up for any number of reasons.
Well, but
Steel
yet-
is shipped late, mortgage financing is readjusted, I mean, it could be.
It would make a lot more housing under
But
the
it- but it
10%
would-
rule, correct?
It would open up tons of opportunities to put in housing. Maybe that's what you want.
Well, perhaps, Your Honor, but that's a different case.
It is.
I'm just trying to work out what the rationale is for the department's regulation, because it seems to me that if you can't be occupied or available for occupancy without having under permit, why it just doesn't say under permit?
I don't know the answer to that
Okay.
question, Your Honor, but I don't think it needs to be answered in order to recognize that the
Unless we agree, unless Justice Spina's question has some import, namely, anyway.
Well, let's suppose, just for the sake of discussion, that you don't have to defer to the agency's interpretation, and let's look at the language of the statute. Section 20 says that the consistency with local needs, which is the touchstone of the ZBA's decision process and the touchstone of the committee's review, that with respect to the 10% threshold, requirements or regulations shall be consistent with local needs when imposed by a Board of Zoning Appeals after comprehensive hearing in a city or town where low or moderate income housing exists, which is in excess of 10%. Our understanding of that plain statutory language is that the board has to, as part of its deliberation, following the comprehensive hearing, in which all of the issues, of which the 10% threshold is one, are ventilated, and it takes evidence, the board has to decide consistency with local needs based on the facts as it finds them as of the appropriate measuring date, which cannot be later than when it's making its decision. And I think that Boothroyd confirms that view, because in Boothroyd, the court made very clear what I think was implicit in your prior decisions, namely that even if the 10% threshold has been exceeded, it's not a goal, as one of my brothers suggests, it's a minimum. And the board is still obligated to deliberate and to decide whether or not it wants to impose requirements and regulations. My brother, one of them, argued that it's important for the town to be able to engage in long-range planning. We absolutely agree. When the board makes its decision, however, it can't engage in long-range planning based on the possibility that something may happen in the future while the case is pending before the Housing Appeals Committee or even pending before the trial court or an appellate court. It can only engage in planning based on the facts as they exist as of the time it makes its decision.
So what is the board to do? I take it then a board, if it has several proposals, any one of which would get them over the 10%, they should delay those that they are not in favor of and expedite the one or two that they are in favor of, and that will settle this problem.
Well, if we assume that the board is treating the 10% minimum as a ceiling, as a goal, then that might be what
No,
they...
it's not. What it's doing is saying it's not a ceiling, but once we've reached that minimum, we will only approve the projects of which we approve. Therefore, we've got 3 projects, any 2 of which will get us over the 10%. At the permit, leaving aside that thing, we're going to expedite, push through 1 and 2 because we want those. And
You're correct, Your Honor. I think the best answer to the question is that's an argument that says that Greenfield had it right, and we should follow the application date, and that even the date that the board makes its decision is too late. It's not an argument that allows the court to say that something that happens after the board has made its decision can somehow be relevant to whether or not the decision that was made was consistent with local needs.
But that's not what seems to me is the clear language of the statute, the language that you just quoted, that those requirements are in place, or that the ability of a ZBA to act on its own without any oversight from the HAC exists when the conditions are imposed by a Board of Zoning Appeals after comprehensive hearing in a city or town where low or moderate income housing exists, which is in excess of 10%. So that language seems to suggest that you do the count at the time of the hearing, or by the time the decision is released in a particular case.
Well, I would agree, Your Honor, that that is the last possible date, which is enough to decide this case. With respect, however, to whether Greenfield is a permissible and the Department of Community Affairs regulation that Greenfield cited as support, whether that's a permissible interpretation of the statute, I would suggest that the language is ambiguous. The Department of Community Affairs thought in 1978 that the application date was consistent with the statute, and indeed that was the best interpretation. And no one even challenged that in Greenfield. I want to suggest that the earlier date is at least a reasonable construction. And why is it a reasonable construction? It is a reasonable construction because the application date provides certainty to the town and to the developer, and I may say to the Housing Appeals Committee and to the courts when they review those decisions. As of that date, we know whether or not the town has crossed the 10% threshold. Indeed, the statute, at another point, talks later in the same provision, says in excess of 10% of the housing units reported in the last federal decennial census, which looks back potentially, I guess, 12 or 13 years, because in Hanover, which was heard in December of 1972, and I believe decided in March, the court says that they're dealing with the 1960 federal decennial census. So I think the statute is not as crystal clear on exactly when the measuring date has to be. What it is crystal clear on is that the measuring date has to be at the time or before the board makes its decision. Thank you, Your Honors.
Thank you. Mr. Weiss?
Thank you, Your Honor. And again, may it please the Court, David Weiss for Rising Tide Development, LLC, and RTD Greenhouse, LLC. I will try to be brief, and I won't go over the ground that Mr. Gruberman has covered, which I accept to say that we join in his arguments. There has been a great deal of discussion about what the right time is in the hearing so far, and I think everyone has a view on that. From the developer's point of view, knowing when you go in to a comprehensive permit process whether you are going to be governed by the comprehensive permit law or by some other law is very important. And the only way to know that is if the date were the original application date. That's the only way for a developer to say, okay, I know what the law governing my project is going to be. Do I have to comply with
In
zoning
fairness,
or
it's
not?
all the comprehensive permit law, it's just which part of it's going to play out, right?
No, Your Honor, if
Either there is 10% or there isn't, and that's going to change the,
yes, I understand what you're saying. If there is 10%, then the developer faces the question, do I want to try to do this project as a comprehensive permit project, or do I want to try to do a different project that's going to comply with zoning because I am not at the absolute discretion of the board and the town?
But do you think Judge Grabeau engaged in too much in the balancing process, that he did something that the legislature really should be doing?
Judge Grabeau explicitly acknowledged that there were policy bases at pages 11 and 12 of his decision, that there were policy bases in the statute which would support the rule in Casaletto and the rule in the regulation. He simply said, and this is a quote, it's close to a quote, goes too far in ignoring the autonomy interest of the town. That is an exercise that it was not appropriate for him to engage in. Judge and I think it's very interesting, the confusion about what's the appropriate exercise continues into Taylor's brief. In Taylor's brief, they say that Judge Kottmeyer said that the Canton decision is erroneous because it fails to provide certainty for the developer. That's not what Judge Kottmeyer said. What she said was the DHCD would not be irrational, that it was rational for the DHCD to conclude that the rule should be determinist as of the time of the filing of the ZBA decision, because it could have said that would provide certainty.
So what happened in this case, in your case? Did the town of Lexington meet the 10% threshold at the time the ZBA made its decision?
No, there is no dispute that at the time the ZBA made its decision, it did not meet the 10%. In our case, we had a pre-hearing order, referred to earlier as a stipulation, in which the town agreed that it had not met the 10%. That's not just a stipulation as to what the present fact is. The purpose of that pre-hearing order, under the agency regulations and in the process before the HAC, is to define what the issues will be for trial at the HAC.
Sure. But that doesn't address Mr. Witten's argument, which may or may not have merit, that one can lose, that the HAC can lose jurisdiction. He's saying if the HAC has jurisdiction, we're not going to argue that point. You know, that's Mr. Weiss. This will fall into a question. There may be an easy answer, and I don't know. Maybe I'm just slipping myself up all over. In calculating the 10%, does one include, in your case, let's say you have a development and the town at the time is close to 10%, and your development will push it over 10%. At the time that the board issues its permit, do you then count your project?
No, Your Honor.
You don't.
It's a question of whether or not the town has already reached, or in the words of the statute, whether there already
No, but
exists.
for the next, if the date is when the permit issues, now you've got developer number 2,
That's
right?
correct.
Does developer number 2 look at the 10% including your project?
or in this case, the 28 units, because that's what the board approved?
Yes. Now, there are some provisions of the regulations that have to do with whether or not there's in fact a building permit that's been issued for a year, and
And it
whether or not
falls
there's an
away.
appeal that's been taken that try to accommodate that. But I think
I
it's-
ask because there has been some suggestion that what one would go back to what the 10% is at the date of application, correct?
well,
And I
people
just want to know, not for you, so at the date of application, you look at the town and it's got 9%.
Well, can a town issue a comprehensive permit on a condition that it's going to be approved at the HAC? Yeah. That the numbers, or I'm sorry, at the time of an application of a new a developer comes in with a new application, there's an appeal pending which could affect the 10% count. Can the local zoning board of appeals somehow preserve its position by saying something up front that this is going to be, your permit is going to be contingent upon that appeal being resolved favorably for the town or the developer? Deny it.
Sure.
Well, what does the appeals committee do then? So, supposing the appeals committee allows a pending appeal, which takes the count over 10%, how does the HAC view this new one that just came up as a denial? If the count is determined at the time of the application, what do they do with that?
If the rule were for any individual applicant, I think the HAC could say,
But the HAC could also take the position, it seems to me, that because there was an appeal pending, the town really did not have like 9% or close to 10%. But at the time this next application was made, and therefore, even though the one we just approved will kick it up to 12%, we were going to, at the time that this new one came through, it was still below 10. It was a denial, and we're going to approve it, and that jacks it up from 12 to 15%.
I think that is correct, and that's one. Not because any of them are perfect, not because any of developers, and in some respects, urban towns. And the question is the irrational? It's certainly not irrational. Here is the time at which you take the standard is.
Thank you, Mr. Weiss. Mr. Hurley?
Good morning, Your Honor. I think the most focus this argument that you encourage. How this unfolded, why we illustrates the mechanics of the approach that we digest. My client, and although the statutory for the, who's miles away from this other project, to bring an appeal as an.
Oh, you mean appealing in the Pequot? Exactly. I'm sorry, okay.
And we thought, frankly, under Rule 11, and we decided that it was a gamble.
So you would want a rule that the date of filing the application applies?
You're in a, from a developer's
Live with the date of the decision.
you know you're going to be considered on the merits.
Before you spend all the money?
You know you're not going to be put into a process.
Mr. Hurley, I know what you're going to say. I think I know what you're going to say, but let me just hold you off right there. If not for you, at the date of filing, how many units did Canton Properties want?
We proposed 200.
Okay, 227 units. So as of the date of filing, right, they clearly were not, the town hadn't reached its 10%.
They were at 7.8%.
Okay. You file, the 220-odd units will push it over the 10%. Okay. Pequot then cannot have the benefit, if it files later, of that 10% rule, even if the permit that is issued is for 100 units and you don't appeal it. So the town is still under 10%. That surely can't make sense. So, I don't know, I mean, it's not good for the developers. It's good for one developer, but not the next developer. So the permitting, at least the permitting, there's a rationale that says, give or take more or less, the town has at least agreed, because it's issued a permit. Maybe it hasn't issued a permit. It's granted a permit with conditions, right? At least the town has agreed that this project, your project, can have at least 20 units or whatever it is. And that seems to me to be more fair to everybody else, because the Housing Appeals Committee may increase it, correct? Or it may be in a denial, but at least at that point the town has said, we approve this number of units. And so surely that's why the date of the issuance of the permit makes sense.
Your Honor,
Well, you can live with the permitting date, is what you're saying.
I can't, Your Honor. I can live with these. And I think that it seems to me that the real regret has to be the board can impose the local conditions and regulations if housing exists on the basis that it chooses to make that imposition. I think
Thank you, Mr. Hurley. We'll take a short break.